From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The January 6th riot at the U.S. Capitol reaches the Supreme Court as the justices debate whether participants can be charged with obstructing an official proceeding under the Sarbanes-Oxley Act of 2002. Meanwhile, the High Court cites the Fifth Amendment's takings clause as it rules in favor of a Californian who was charged $23,000 in permitting fees. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnists Kim Strassel and Alicia Finley. The case at the Supreme Court on Tuesday was Fisher versus United States. Joseph Fisher was a local police officer in Pennsylvania who was at the Capitol on January 6th. Some of his text messages include, "Take Democratic Congress to the gallows. Can't vote if they can't breathe, LOL." The government alleges that he crashed into a police line. He was charged with several crimes, including assaulting a federal officer. But that is not what is at issue at the Supreme Court. Prosecutors added a charge for obstructing an official proceeding under a law called Sarbanes-Oxley that was passed in the wake of Enron and other corporate scandals. Kim, what is your read of this case? It seemed to me that some of the justices were skeptical of the government's position that Sarbanes-Oxley covers what happened on January 6th.
Yeah, and rightly so. Just think about that statement, Kyle. And sometimes when things make no sense, it's because they really don't make any sense. I mean, look, it's totally possible to both have real issues with what the Capitol protesters did and their behavior and hope to see some justice, and also not believe that this particular law is the way that you go after them. And what we're looking at here is a particular section in Sarbanes-Oxley, which obviously was passed in the wake of Enron and was clearly focused on financial crimes. But there's a section of the law that makes it a crime to shred or hide documents corruptly with an intent to impair their use in federal court or in a congressional investigation. That is then immediately followed by a sort of catch-all provision that also says that you can be in trouble if you otherwise, and the word otherwise is important here, otherwise obstruct or influence or impede such a proceeding. The federal government has decided that, therefore, engaging in a protest, as it were, walking into the Capitol, was obstructing such a proceeding that it falls under the otherwise category, and that, therefore, in addition to other charges that these people have been hit with, they can be hit with Sarbanes-Oxley as well, too. The justices were rightly skeptical, I think mostly just on a reading point, and I think that, the Chief Justice put it the right way, which is that you have to read those two provisions together. If you do, and if January 6 defendants are not accused of altering evidence, then nothing that follows in the next clause would apply to them. That's the sort of main way of looking at this. But I think that the justices also asked some very good questions about some of the problems that would be attendant if you did allow such an expansive reading of this law. Where would be the limits? And, Neil Gorsuch pointed out, if you're sitting outside a federal courtroom in a peaceful sit-in, can you be charged with this? If you were a heckler at the State of the Union address, could you be charged? Or, and this is the one that gave me a giggle, if you pulled a fire alarm before a vote in Congress, which is notable only because obviously Democrat Jamal Bowman did just that recently. And so should he be charged with a Sarbanes-Oxley crime? I think one last thing that was worth noting in terms of skepticism is that justices do care very much about history and precedent, but also the way that laws have been used. And several of them noted that this law has now been on the books for 20 years and that has never been used in such a way before, which is usually for justices a big tip-off that somebody's trying to be overly expansive.
Let me read the section of the law at issue here. It says, whoever corruptly, number one, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. Or, number two, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. And so as Kim lays out, we have the spectacle here of Ivy League trained lawyers now arguing about the meaning of the word otherwise. Here is Justice Elena Kagan during the oral argument.
It seems to me there are two choices here, and you could read this as otherwise obstructs a proceeding or otherwise spoils evidence. And you're using it to say otherwise spoils evidence with, spoils being all those verbs. But it doesn't say that. It says otherwise obstructs a proceeding. There are plenty of ways to write the statute that you want to write. You could just say otherwise affects the integrity or availability of evidence in an official proceeding. You could combine official proceeding with evidence in other ways. One with, you could replicate the mens rea that C1 has. I mean, there are ways in which C2, multiple ways in which the drafters of C2 could have made it clear that they intended C2 to also operate only in the sphere of evidence spoliation.
I think I disagree with Justice Kagan there. My reading of this statute is if you have a number one that is all about destroying or hiding or altering or mutilating evidence, and then a number two that says or otherwise affects official proceeding, I read that otherwise to mean something related, something similar to number one. Otherwise, why is number two not number one? Otherwise, you could just write the law that says don't obstruct an official proceeding, and you could leave it at that. But Alicia, one thing I do like about this case is that it shows the conservative justice's textual philosophy at work. Here is the law. What would a normal, ordinary reader of this law take that to mean when it was enacted? And so this case is kind of a language puzzle.
Right. And it was Justice Elena Kagan who, recall, said, we're all contextualists now. And Chief Justice John Roberts mentioned actually an opinion that came out on Friday, which would directly contradict the government's argument. And in that opinion actually also concerned how to read the text when you have one section directly following the other. And the Solicitor General, Elizabeth Prelogar, really didn't have a response for that. One other point I would mention is also what is the limiting principle here? And I think even the liberal justices were trying to get at this a little bit because they don't want to read this too expansively so that it would become a dragnet for all kinds of conduct. But they were trying to divine whether, well, how much weight does the word corruptly entail? And I think there was one question or a couple of questions, well, like, must it be a minimal or significant obstruction? Though, of course, the law itself doesn't specify that. And that would actually contradict another opinion that the Supreme Court put out just actually today. And so that's the issue with the government's argument, is that it's just so broad that there really is no limiting principle. And this is a particular issue with criminal statutes, and where there's the actual due process problem when there's kind of a vague statute. I don't think this statute in itself is vague, but in the past, the Supreme Court has actually struck down laws void for vagueness because they're so vague and the defendant doesn't know what conduct is actually criminal. And if you were to take the government's reading or interpretation of this law, I think it would be so vague and so broad that that same concern about due process would apply.
Hang tight. We'll be right back in a moment. Welcome back. Let's listen to another clip of the oral argument. This is Justice Neil Gorsuch questioning Solicitor General Elizabeth Prelogar. This is the clip that Kim mentioned earlier and gets at this point about the lack of limiting principle in the government's interpretation.
Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
There are multiple elements of the statute that I think might not be satisfied by those hypotheticals, and it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations are the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512c2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference.
So her argument there is that some of those hypotheticals like standing up in the middle of a Supreme Court argument and yelling for about 30 seconds before you get dragged out by the police there, that would not qualify as a true obstruction. But it seems to me, Kim, that the conservative justices are not going to buy that argument. And part of it is that argument, to my eye, is not built into the text of the law. And by the way, I would cite another hypothetical. This was one in a dissent in the D.C. Circuit Court of Appeals. The judge there, Judge Gregory Katz's, had this hypothetical: a protester who demonstrates outside a courthouse hoping to affect jury deliberations has influenced an official proceeding or attempted to do so, which carries the same penalty. And so he was of the view that accepting the government's position here in this case would supercharge what are relatively minor crimes for disorderly conduct and so forth into 20-year felonies.
Yeah, according to the Solicitor General, apparently obstruction is in the eye of the beholder. And that should always make people worry, especially when it comes to law enforcement. As you say, Kyle, I think what made many of the justices uncomfortable up there, at least the conservative justices, was that there seemed to be no limiting principle here, just that any time you did anything that presumably could be labeled obstruction, no matter how wild that claim is, the Department of Justice could charge. But also, again, the nature of the argument that, well, some things would be obstructions, some things wouldn't, we'll let you know when we see it. That's always a very dangerous type of power to give to law enforcement. One other thing that came up here, which I just think is very important and people should understand as well, is whether or not this is even necessary, having this kind of power, which is also important. Most of the people who engaged in January 6th have not been hit with this obstruction charge. And even those that have been hit with it, they've also been hit with many other underlying charges for the most part. This charge appears to have been reserved for the more serious cases, and in almost all situations, I think maybe all situations, has been levied on top of underlying charges. So, for instance, the accused in this particular case who brought suit, he's been charged with 6 other counts of issues that he will face, regardless of this one stands. And this was something else that a number of the justices brought up, which is why having this power is it so necessary? And I think that's an important part of this argument, because there really wasn't much of an argument there either from the government about why their ability to go after people somehow hinged on this enormous stretching of this one provision.
To add to that, I'm just looking at the indictment for Joseph W. Fisher, and the charges that he's facing include civil disorder, assaulting, resisting, or impeding certain officers, entering and remaining in a restricted building or grounds, disorderly and disruptive conduct in a restricted building or grounds, disorderly conduct in a Capitol building, parading, demonstrating, or picketing in a Capitol building. So I think that that's right. Even if he wins this case, that does not get him off the hook for what he is alleged to have done on January 6th. And I think that is probably also true for these other defendants. Just looking at some figures in an Associated Press story, it says that more than 1,350 people have been charged with Capitol riot-related federal crimes. Approximately 1,000 of them have pleaded guilty or been convicted by a jury or judge after a trial. And according to this same story, about 330 people are facing this obstructing Congress charge that is at issue in the case before the Supreme Court. And so, Alicia, I sort of agree with Kim here that it is not clear why prosecutors need this kind of power if those people can be charged with other crimes. And I understand that it's disruptive if there are 330 indictments that are now going to have some sort of process happening to either change those charges or alter the indictments. But the blame for that, I think, is not at the feet of the Supreme Court. It should be at the feet of the prosecutors if they're the ones who are stretching the law in a way that the Supreme Court says is not permitted by the text of the law.
The question you raise is right. Well, why did they need to throw this charge in other than the fact, one, prosecutors just like to throw the book at defendants and ring up as many charges as possible. You see that with the Alvin Bragg case, who filed 34 charges basically on the same kind of a claim. So that's a potential, is they just want to tack on the penalties. And this one, I guess, carries a maximum 20-year sentence in prison. Now, the Solicitor General said, well, Most people aren't actually being sentenced for that. There's no minimum sentence, so the judge could really only sentence a defendant here or others for maybe 1 to 2 years. And the actual sentences for this crime or the crime that under Sarbanes actually isn't really that much. Maybe the maximum sentence is longer than the maximum sentence for the other crimes, but the average sentence really isn't any different. And I think she kind of was a little squishy with that. I think the reason why they did bring this charge is because it had a longer maximum sentence. I think another reason is prosecutors just do want to expand their powers, and they use these kind of test cases. And if this one gets held up, they'll probably, bring another case, maybe similar, or you could see actually maybe under Trump administration, the Justice Department doing the same against some protesters outside the Capitol, progressive protesters or something like that. And they'll take the same reading of Justice Departments of both parties like to stretch the laws and make them as malleable as possible.
And one example of that may be worth noting is another time that this same law, Sarbanes-Oxley, was before the Supreme Court. This involved a different section that prohibits altering, destroying, mutilating, concealing, covering up, falsifying, etc., any record, document, or tangible object. And the question in that case was whether fish could count as a tangible object. A boat was pulled over, and the claim was that after he had been pulled over, he threw some of the fish back or something like that and was charged with destroying a tangible object. And that was not accepted by the Supreme Court, which is their role to rein in prosecutors when they are going too far. The majority in that case of the term tangible object is better read to cover only objects one can use to record or preserve information, not all objects in the physical world, unquote. But Kim, notable that was a 5-4 decision, and I don't know if it will be 5-4 on Fisher with the January 6th obstruction, because it does look like the petitioner here did not convince Elena Kagan, for one.
Yeah, I don't know what the final count will be, but I find it notable that this is not the first time this law and this provision has actually got a hearing. And it just goes back to something else, which is that Sarbanes-Oxley, one thing that all of the justices seem to agree, is not a model of clarity. And a little reminder as well to our congressional legislation writers that they need to think a little harder when they write some of these laws so that we aren't constantly ending up in this situation. Just if you have a lot of complaints about Congress, it's one more to add to the ledger.